Welcome back, brothers and sisters. I am Braden. This is Langley Outdoors, the place where we not only talk about what's going on in the gun world, our beautiful country, how we're going to fix this bad boy together. And guys, this is becoming the never-ending update for positive action, because we have something that just dropped from the DOJ telling a gun-controlling senator the old backhand that, hey, we're not going to pursue this to Supreme Court like you want us to. The gun control and taking guns from people like you want us to. It's official. You can write us down as, yeah, we're going to withdraw any type of support for this. This is what I'm talking about. Make sure you send this one out. Hit that like button. Subscribe to the channel. Turn the notification bell on because YouTube is unsubscribing people. I'm telling y'all. But let's jump right into it. First, we're going over here my profile on X, at BradenLOA. We are going to dive into something together. If you want to follow me, it's right there. There's a link in the description. It's a party over there, but that's not why you're here. Why you're here is this amazing piece of news right here. So, as a refresher, kind of a primer on where we've been, again, this is Saturday. We're not used to having news like this drop on Saturdays. Last week, this is what was circulating in the gun rights world. The DOJ's inaction secures victory in Range versus Attorney General's Second Amendment case. As you can see, my buddy Bill Kirk at Washington Gun Law, this is big news on the issue of nonviolent felons getting their rights restored. This could prove to be huge. Absolutely. Now, I haven't covered this in depth yet because I wanted to wait and see what the DOJ was going to say. We now know what they're going to say because they just sent a letter to Dick Durbin, the gun-controlling little senator from Illinois who is retiring, that he's not going to get his way in this one. Check this out. All right. Breaking from GOA about an hour or two ago. Department of Justice confirms it will not be appealing to the Supreme Court in Range versus U.S. This means the Third Circuit's decision that the code is unconstitutional as written and the right of nonviolent felons to keep and bear arms will stand. This is a massive victory. You remember all the actions that the DOJ was taking about a month ago where they were putting together a rights restoration committee inside the 2A task force as a result of the executive actions to support the Second Amendment from Trump? This is a piece of this, okay? Now, as we keep going here, let me show you this documentation the DOJ just sent Dick Durbin, Democrat minority whip in the Senate. Look at this. Okay, actually, that's not going to, I got to do this. Hold on. Here we go. Come on, Braden. There we go. All right. This was sent on April 11th, 2025 from the Solicitor General, so this is official. The Honorable Richard J. Durbin, Ranking Member, Committee on the Judiciary, United States Senate, Washington, D.C., Range versus Attorney General, United States. This is the nonviolent felon case, and listen to the example. Dear Senator Durbin, pursuant to the code, I am writing to advise you that the Department of Justice has decided not to file a petition for a writ of certiorari in the above captioned case. A copy of the opinion issued by the en banc United States Court of Appeals for the Third Circuit is enclosed. Wow, that sentence was hard for me. But this is what we're talking about right here. Range versus Attorney General, United States. The DOJ is not filing a petition. They're not even asking SCOTUS. They're like, nah, we're good. We feel pretty comfy. All right, let's keep going. In this code, Congress prohibited a person from possessing a firearm if he has been convicted of a crime punishable by imprisonment for a term exceeding 1 year. The plaintiff in this case, Brian Range, was convicted in 1995 for food stamp fraud after he signed an application for food stamps that understated his income. So he floated his income on a food stamp application. Ooh. Although that offense, which was classified as a misdemeanor under state law, was punishable by up to 5 years of imprisonment, Range received no jail time. Range has had a clean record since then, apart from minor traffic and parking infractions and a summary offense for fishing without a license. Okay. The en banc Third Circuit held that that section violates the Second Amendment as applied to Range. This is important, as applied to Range. So this is precedent setting. Okay. This is a narrow review of this case, but it can be pointed to from other cases. The court described its decision as narrow, emphasizing that Range's misdemeanor conviction for food stamp fraud was decades old, that Range had filed a civil suit in which he sought protection for future possession of a firearm, and that the record contains no evidence that Range poses a physical danger to others. So, you get your gun rights back. They're not sending this to the Supreme Court. If this was on the Biden administration, the Biden DOJ, I guarantee you this will be going to the Supreme Court and asking for writ of certiorari to basically take people's rights away for mail stamp fraud, or food stamp fraud, excuse me. It's so stupid. But point is, DOJ now is not doing it. The Department of Justice has concluded that a petition for a writ of certiorari is not warranted in this case. The Third Circuit's decision is narrow, leaving that code untouched, except in the most unusual applications. The Supreme Court has previously declined to grant plenary review when faced with similar decisions, holding the section unconstitutional as applied to a narrow set of circumstances. In addition, the Department of Justice has recently revitalized an administrative process through which an individual may obtain relief from federal firearm disabilities if he shows that the circumstances regarding the disability in the applicant's record and reputation are such, that the applicant will not likely to act in a manner dangerous to the public safety, and the granting of the relief would not be contrary to the public interest. Guys, the DOJ has just pulled any kind of support from this. Like this right here, they're saying, no, it's not going to SCOTUS. We're fine with where it sits. That's a win. And, I've got to beg the question. If you see step in the right direction, 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 when does it become we're walking in the right direction? It's a real question. You guys can let me know what you think in the comments field on that one. But let's keep going. Let's wrap this up. Because the Court of Appeals has not yet had the opportunity to consider the effect of that action on the constitutional analysis, and because Range himself would likely qualify for relief under the revitalized process, the department has concluded that the Supreme Court's intervention is not warranted at this time. Please let me know if I can be of any more assistance, the Solicitor General. Guys, this is a pretty big deal, and the reason that it's a big deal is because people who had their rights taken away from them are now no longer having them taken away from them, and an application process has gone through to where they can get those rights revitalized. Guys, these are steps in the right direction. I'm sorry, we're getting to a point now where we have so many, as we say, steps in the right direction. We're getting now to we are walking in the right direction. Now, I'm not going to sit here and tell you we're running in the right direction and we're going to go bang our drum that we've won and the fight's over and everything's golden. Nope, you're not going to hear me say that. However, when I see this many steps in the right direction, of which we have covered on this channel for the last 2 months, really month is when it's really been picking up, the accolades deserve to be showered on people who put that many steps in the right direction. Now, I'm going to do videos on this in the future where it's laying out the entire battlefield map, because this is something that you can see a lot of movement when you zoom out on. But I don't know. You guys let me know what you think in the comments field below. Are you excited about this? Or do you think this is something that should happen? I need to hear from you. And more importantly, this is the part that I really want to get your perspective on. How many steps in the right direction does it take before we start noticing that there's a walking and momentum building in the right direction? That's probably the biggest question that I have for you guys, because to me, we're walking in the right direction. It's no longer just an incremental step. We are now taking step after step after step, and we're walking in the right direction. Backhands will still be delivered if we take steps backward, but it seems to me that there's a walk establishing. I don't know. You can let me know what you think in the comments down below, and I'll see you on the next one. I'm Braden. See you later.